The common market for East and South Africa traces its genesis to the mid-1960s. The idea of regional economic cooperation received considerable impetus from the buoyant and optimistic mood that characterized the post-independence period in most of Africa. The mood then was one of Pan-African solidarity and collective self-reliance born of a shared destiny. It was under these circumstances that in 1965 the United Nations Economic Commission for Africa (ECA) convened a ministerial meeting of the then newly independent states of Eastern and Southern Africa to consider proposals for the establishment of a mechanism for a promotion of sub-regional economic integration. The meeting, which was held in Lusaka, Zambia, recommended the creation of Economic Community of Eastern and Central African States. An interim council of ministers assisted by interim economic committee of officials was subsequently set up to negotiate the treaty and initiate programs on economic cooperation pending the completion of negotiation of the treaty. In 1978, at a meeting of ministers of trade, finance, and planning in Lusaka, the creation of sub-regional economic community was recommended, beginning with a sub-region preferential trade area which would be gradually upgraded over a 10-year period to a common market until the community had been established. To this end, the meeting adopted the Lusaka Declaration of Intent and commitment to the establishment of preferential trade area for Eastern and Southern Africa (PTA), and created an intergovernmental negotiating team on a treaty for the establishment of the PTA. The meeting also agreed on an indicative timetable for the work of the intergovernmental negotiating team. After preparatory work had been completed, a meeting of heads of states and governments was convened in Lusaka on 21st December 1981, at which the treaty establishing the PTA was signed. The treaty came into force on 30th September 1982 after it had been ratified by more than 7 signatory states as provided for in Article 50 of the treaty. The PTA was established to take advantage of larger market size to share the region's common heritage and destiny and to allow greater social and economic cooperation, with ultimate objective being to create economic community. The PTA treaty invested its transformation into a common market, and in conformity with this, the treaty establishing the common market for Eastern and Southern Africa (COMESA) was signed on 5th November 1993 in Kampala, Uganda, and was ratified a year later in Lilongwe, Malawi on 8th December 1994. It is important to underline the fact that the establishment of PTA and its transformation into COMESA was in conformity with the objective of the Lagos Plan of Action and the Fine Act of Lagos of the Organization of African Unity, both the RPA and the FAR engaged an evolutionary process in the economic integration of the continent within regional economic communities would constitute building blocks upon which the creation of African economic community would ultimately be elected. The Common Market for Eastern and Southern Africa (COMESA) is a regional economic community in Africa with 21 member states stretching from Tunisia to Eswatini. COMESA was formed in December 1994, replacing preferential trade area which was existed since 1991. 9 of the member states formed a free trade area in 2000: Djibouti, Egypt, Kenya, Madagascar, Malawi, Mauritania, Sudan, Zambia, and Zimbabwe, with Rwanda and Burundi joining the free trade area in 2004, the Comoros and Libya in 2006, Seychelles in 2009, and Tunisia and Somalia in 2018. COMESA is one of the pillars of the African Economic Community. In 2008, COMESA agreed to an expanded free trade zone, including members of 2 other African trade blocs, the East African Community and Southern African Development Community. SADC. COMESA is also considering a common visa scheme to boost tourism. Its members include Djibouti, Eritrea, Ethiopia, Somalia, Egypt, Libya, Sudan, Tunisia, Comoros, Madagascar, Mauritania, British Seychelles, Burundi, Kenya, Malawi, Rwanda, Uganda, Eswatini, Zambia, Zimbabwe, and the Democratic Republic of Congo. Former members include Lesotho, Mozambique, Tanzania, Namibia, and Angola. According to the treaties, the following organizations have decision-making power: the COMESA Authority, composed of heads of states or governments, and is COMESA's supreme policy-making organ. The authority is headed by a chairman elected for an agreed period. The current chairman from November 2021 is Egypt's President Fathi el-Sisi. The authority is taken with the general policy direction and controlling the overall performance of the executive function of COMESA. The COMESA authority meets once a year at summits which are held in different member states. The hosting government and the COMESA Secretariat bear joint responsibility for their organization, whilst the host country assumes the chairmanship of authority for the year. An extraordinary meeting can be held at the request of any member of the authority, so long as 1/3 of the members of the authority support such a request. The authority meetings are held in closed sessions and usually decisions are taken by consensus. The session leaders have to issue a communique recording any decision made. Their directive and decisions taken by authority are binding on all member states and other organs to which they are addressed. There is also COMESA Council of Ministers. COMESA Courts of Justice decisions have precedence over any decision of national courts. The Court of Justice may receive cases not only from member states but also from natural and legal persons against the Council to determine the legality of any act towards the derivatives, regulations, or decisions made. The persons are also permitted under the treaty to issue a member of state in the COMESA court the legality under the treaty of any act, directive, regulation, or decision of such a member state. In the event that a member state's court is reviewing the application or interpretation of the treaty, it may request the court's opinion on the matter. If the national court is a court from which there is no appeal or remedy, then court is required to refer the question to the COMESA court. The national remedy must be exhausted before a person can bring a matter to the COMESA court of justice. The COMESA court has jurisdiction over suits brought by COMESA employees and third parties against COMESA or its institutions. It also may act as an arbitrary tribunal on any matter arising from a contract to which COMESA or any of its institutes is a party. is a part. Further, the court can adjudicate any dispute between member states who agree to bring the dispute before it. Unlike the statute of the International Court, the treaty does not state the source of law to be applied by the court. The treaty and any COMESA issued legal instruments will make the initial law to be applied, but municipal law and international law may also be determined applicable by the court. While the jurisdiction of COMESA court provides multiple avenues for the creation of standard interpretation of treaty, there is no specific provision of avenue for settlement of disputes between institutions of the common market. The court is not given the power to interpret the statute of other COMESA institutions. Finally, the treaty does not specify that the court will have jurisdiction over human rights issues within the context of community. Due to its varying jurisdictions of the court, the 8th meeting of Ministers of Justice and Attorneys General recommended to the Council of Ministers and the authority that the treaty be amended to provide for two divisions in the court of first instance and the appellate division. The proposal was adopted and the court was expanded in June 2005 with appointment of 7 judges in the court of first instance and 5 judges in the appellate division. The work of the court was then suspended until the appellate division judges were appointed and the rules of court of appellate division were drawn up and adopted. During this reformation of the court, the previously fully independent court was made subject to the review of any proposed rule of the court by the Minister of Justice and the Attorneys General. The court was established under 1994 treaty. The first set of judges was not appointed until 1998. Unlike other African region courts, the COMESA court continued to receive cases. However, due to the lack of funds, the court is unable to hear all its cases at certain time. Funding is only done for one session of the court per year. These have contributed greatly to pending cases. The backlog of cases will most certainly increase with the current growth in trade disputes in the region. Thank you for being with us today. We have focused about common market for Eastern and Southern Africa, COMESA, with the anthem People of Africa, with its secretariat in Lusaka, Zambia. Official language Arabic, English, French, Portuguese. Type trade bloc with 21 member states. Head, Leader, Secretary General, Chilesh Pundu Kwakeke. Establishment Agreement signed on 5th November 1993 and ratified on 8th December 1994. Thank you very much for being with us. Today we have focused about COMESA. See you in the other upcoming videos. Bye.